Welcome to the 13th episode of Beyond Retirement Learning Series. This is sponsored by Senior Edge Legal, and I'm Susan Graham, a certified elder law attorney based in Boise, Idaho. Today's topic is the dangers if you fail to coordinate your titled assets with your estate plan. There are multiple purposes for providing this service to you. First of all, to give you the opportunity to have some useful information and see if we might be a good team member to add to your estate planning team. In addition, we want to share with you free legal forms that you can obtain, and also you can say if you want to visit with me. There's an evaluation form at the bottom of your page that you can fill out any time for those forms or to fill out the evaluation form to visit with me. Well, let's talk about today's topic, and that is the dangers if you fail to coordinate your estate planning assets with your estate plan. Why do you care about this? Well, under the law in the state of Idaho, if a dead person owns real property that's titled in their name, we have to probate their estate. That means somebody has to go to court and say, Judge, give me the permission to be able to sign on behalf of the dead person. That takes time and certainly takes money, and then you get the overlay of the court process. In addition, if you have other titled assets, so you have no real property, no house, no cabin, no condo, no oil rights or mineral rights, but you have cumulative value of other titled assets that exceed $100,000 that are in the name of the dead person. I'm talking RVs, other vehicles, bank accounts, CDs, brokerage accounts, those kinds of things. So how do you do this? How do you coordinate those assets with your estate plan? If you have a will-based estate plan, meaning you have a last will and testament that says, and when you die, who's going to be the personal representative, and then also where the assets are to go, one of the things you need to think about is, okay, you can't really put assets in the name of a will. Those assets would be in the name of the decedent, but you can change the beneficiary designations on the number of assets to coordinate them with your estate plan. What I'm talking about is you could make your bank accounts, POD accounts, to the personal representative of your estate or another individual that you want to have receive them. That's a form you have to fill out with the bank for your bank accounts, checking accounts, and savings accounts. For your life insurance, if you want it to be split up among different people or charities that you've listed in your will, then you need to name the beneficiary of the life insurance to be my estate or your estate, the estate of Susan Graham, or what your name you put in your name. Obviously, don't put my name. Then the other thing you need to consider is who's the beneficiary of your retirement accounts. Now this gets tricky. If you say my estate is the beneficiary of my retirement accounts, you're going to accelerate the income tax associated with that IRA. When you create that IRA, or individual retirement account, or some of the other retirement accounts, you shoved money in there without paying any tax. And that was smart. Everybody told you to do that. And it grew and grew and grew, and you didn't pay any income tax on that. But when the money is withdrawn, you have to pay income tax. And if you name your estate as the beneficiary, because that says under your will how things gets divvied up among different people or charities, that will accelerate the tax, meaning the tax on all that income that was shoved in there will have to be paid within 5 years of your death. As opposed to if you named individuals, the tax would be paid out over a 10-year period. It just means the tax has to be paid faster, which means generally there's more money that's paid out and less in your family's pocket. So let's talk about what else you can do if you have a will-based estate plan and how you title assets. One of the things you can do is if you want, you can say, my house goes to my surviving spouse. And you have to do that with either a document that's called a devolution agreement, which is just basically a contract that gets filed with the county that says you want your spouse to get the house, and you have the legal description of the house in that contract. And no matter who dies first, at least we don't have to probate the estate relating to that house or the real property that you own in Idaho that's identified in that contract. Another thing you can do, there's a relatively new law in Idaho that you can have survivorship benefits between husbands and wives in a deed. So that's a possibility. Another thing you can do relating to real property, you can reserve a life estate, meaning for your home, you get to stay in the home for your rest of your life. But when you die, you can say, the home goes to my child or my 2 children. That's called a gift deed, reserving a life estate in the grantor, that's you, and the remainder interest, when you're dead, the interest in the house goes to your kids or whomever you say it's going to go to. That too can help avoid a probate. If you're going to use these kind of techniques, I just strongly encourage you to work with an attorney, an estate planning attorney, who can help you do this properly so you don't shoot yourself in the foot and lose the homeowner's exemption or have some gift tax problems. If you have a trust-based estate plan, a revocable trust-based estate plan, coordinating your assets with your estate plan is slightly different. What you do in this circumstance is the deed to your home and other real property would be transferred into the trust name now while you're alive. Well, that means that the trust owns it, and the person who can sign on behalf of the trust is the trustee. That's normally you, but then you have backup people when you can't do it. If it's a husband and wife, it's the 2 of you usually, or the survivor. But then who's going to handle it when you're both gone? Could be a child or a friend or a bank. But that trustee then will be the one who's titled on the name of that asset, so it's easy for them to sell it. It's not in the dead person's name when you're both dead or you as an individual are dead. It's the trustee who's the one who owns it, and they can sign the title and transfer it wherever it needs to go without a probate. The other assets that you own, if you have a trust-based estate plan, a revocable trust-based estate plan, would be mutual funds, brokerage accounts, partnerships, things like that. Those normally are transferred into the trust right away, now, while you're still alive. You're the trustee of that asset, it's in the name of the trust. And the tax ID numbers for those assets is your Social Security number. Other things that have beneficiary designations, such as life insurance, retirement accounts, annuities, you would name the trust as the beneficiary when you or you and your spouse are both dead. This time the tax laws are different. They don't accelerate the death tax on the retirement accounts, so that tax can be dragged out over a longer time period, and currently under the law it's a 10-year time period before the tax will fully be paid. And again, you can make your bank accounts, POD accounts, paid on death accounts, or sometimes they make them transfer on death accounts, TOD accounts. The result is exactly the same. Sometimes people think the way that title their assets relating to their estate plan is to have joint accounts. You put a child's name on your checking account or a savings account. You think that that's going to make life easier and that it's still going to go equally among all your kids or whatever you wanted, even though you've only named one child on that account. That creates chaos. Under Idaho law, the law presumes that that child's name was put on there for convenience, and it still needs to be the money that's left in that account, assuming it was all your own money. That's going to be divvied up according to your estate plan, or if you don't have an estate plan, according to what the Idaho Code has come up with. But let's talk about the real world. The child whose name is on the account usually says, oh, this is cool, it's my money. And they're not willing to put it back in the pot and use it to pay for the death expenses or share it according to the estate plan of the decedent. So even though that might be practical for short-term activities like paying bills when you're out of town or paying bills when you're ill, assuming this is a responsible child and the child doesn't clean out the account and leave town, but assuming you've got a good child there, again, by doing that, you created some chaos in terms of when you die as to who's grabbing the money and how that's going to be spent appropriately. So it's important to pay attention to these things. These are easy ways to shoot yourself in the foot with a shotgun doing common sense things that don't really match up with what the law provides. There truly are dangers in the assets that you hold and how you title them and how that ultimately gets coordinated with your estate plan. Common sense doesn't always work for you in this area. So if that's a concern of yours, I strongly encourage you to come see me or another attorney of your preference that handles these kinds of issues. Next time, we're going to talk about the dangers of titling real property in the name of the trust, doing it the right way and the wrong way. I want to encourage you to fill out that evaluation form at the bottom of your screen. That will, first of all, give you access to the legal forms I spoke of your financial power of attorney and health documents and other forms. In addition, I would appreciate if you would critique me and tell me how I can improve and other topics that you would like me to address. Lastly, if you want to visit with me, there's a way to indicate that on the form, and someone from my office will contact you. Thank you so much for listening to this today.